Do New York State's rules requiring insurance coverage for medically necessary abortion services violate the free exercise clause of the Constitution? To find out, you have to read Roman Catholic Diocese versus Vullo, but it's 26 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Roman Catholic Diocese versus Vullo. The citation for this case is 2024 New York Slip Opinion 02764, published by the New York Court of Appeals on May 21st of 2024. The issue in this case is whether the religious exemptions for religious employers in abortion insurance rules by New York State violate the free exercise clause of the Constitution. To understand it, this is a little complicated, but to understand and appreciate the context of this case, the basic background that I think is helpful to know is that the First Amendment to the United States Constitution, the First Amendment to the Bill of Rights, talks about a free exercise clause. There's a right to free exercise of religion, which states that Congress shall make no law prohibiting the free exercise of religion, which has been passed down to the states through the 14th Amendment. And it's implicated, it's violated, if a law discriminates against some or all religious beliefs or regulates or prohibits conduct because it's undertaken for religious reasons. Importantly, there's a case called Employment Division versus Smith from 1990. It's a United States Supreme Court case. It states that the right of free exercise, that free exercise fundamental right under the First Amendment, does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability that may incidentally impact religious conduct. So if a law is facially neutral and generally applicable, it's valid, even if it has some incidental impact on religious liberty, because it's not designed to damage or impact religion. There's another case. The last thing you have to know is that in 2006, New York State, there's a New York State case from the Court of Appeals called Serio, S-E-R-I-O, 2006, that basically analyzed the New York State insurance rules with respect to contraception. And the same exception rules that we're going to talk about in a few moments. And the question was, does the law requiring insurance coverage of contraception violate the free exercise clause with respect to the Catholic Church? And the answer is no, it does not. It's a facially neutral law of general applicability. That's the case of Serio. All right, so what are the facts in this case? The facts are that in 1972, the Department of Financial Services put forward a regulation stating that no health insurance policy should limit or exclude coverage outside of certain specified exceptions. Okay? There's like a floor of coverage of what insurance has to cover. In 2013, the Affordable Care Act gave a model template of what the insurance has to cover, and it included coverage for medically necessary abortion services. If you provide insurance in this state for employees and you're an employer, you must cover medically necessary abortion services. There's an exception if you're a religious employer. If you're a religious employer, the employee still has to get coverage for medically necessary abortion services, but there's a special procedure where the insurance company can issue a special rider to provide it. But to be defined as a religious employer, there's 4 elements to it. The elements are that it's an entity for which each of the following are true. Number 1, the inculcation of religious values is the purpose of the entity. So purpose is number 1. Number 2, the entity primarily employs persons who share the religious tenets of the entity. So the employees is number 2. Number 3, the entity serves primarily persons who share the religious tenets of the entity. So the third is that the people served have to have the same religious tenets. And number 4 is the entity is a not-for-profit under IRS regulations. The Catholic Diocese, in this case, the Roman Catholic Diocese of Albany, did not try to certify under this religious employer exemption, and they said we can't because we don't know. Oh, so here's what happens: the Diocese of Albany the Carmelite nuns run a nursing home, amongst other plaintiffs, but they run a nursing home, and they say we can't necessarily certify that everyone who works for us has the same religious tenets as we do, and we can't certify that everyone we serve, because we're serving people that need nursing home services. We're not saying that every single person we serve has the same religious beliefs as us, but we are not covered by this religious exemption, and we should be. So you're violating our free exercise fundamental right in the First Amendment, and they move to say this is unconstitutional. there was a case while this case was pending called Fulton versus City of Philadelphia, where the United States Supreme Court basically said that the Philadelphia rule, where they basically gave the commissioner of the insurance of the city the ability to uncertify certain contracts for foster care based upon whether they are complying with Philadelphia's rules. Basically, the commissioner said, we're not going to continue working with the Roman Catholic Church because they're not providing foster care services to same-sex couples. That was found unconstitutional. That law was found unconstitutional because there was too much discretion in the hands of the commissioner. It was not facially neutral and generally applicable because of this discretion that the commissioner had. So the question in this case, the appeal in this case, and the legal question is, does Fulton undermine Smith? Does that Fulton decision, where they found it unconstitutional, does that mean that this law is now unconstitutional? And the answer from the Court of Appeals is no. It is still facially neutral and generally applicable. Sirio is still good law. And if Sirio is good law with respect to contraception, using the same exemptions for religious employers, then this, for requiring medically necessary abortion services, is equally valid and constitutional under the principles of stare decisis, which basically means that the court should be following precedent, should be following what the prior rulings are by appellate courts, unless there's some reason to overturn them. So Sirio controls. Under Sirio, this exemption, this law is facially neutral and generally applicable, and not a violation of free exercise. And therefore, in this case, with respect to the Vullo, it is still constitutional, facially neutral, and generally applicable. And that's the case of Roman Catholic Diocese versus Vullo. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.